Senator Markey.
Thank you, Mr. Chairman, very much. I enjoy this conversation because we're kind of in the Wayback Machine to a certain extent. When Senator Daines holds up a cell phone from 1992, because when I authored this law in 1991, I am the author of it, it was because there was an epidemic of calls that were going into people's homes. There were no laws. And so people were almost afraid to look at their phone at night because it would just start to ring at about 6 o'clock and it wouldn't stop until 9:30 or 10 at night. So we had to put a law on the books. So I was the chairman of the Telecommunications Committee. It's my law. And to Senator Daines's point about the primitive nature of the phone which he had in his hand, I also knew that we were putting in 200 megahertz of spectrum so that we could create the third, fourth, fifth, and sixth cell phone license in America, that we would go digital and everyone would have one in their pocket by the year 1995. So that's how quickly that all changed. So we were building in, I was building in, anticipatory consumer protections. Now, when people hold this phone in their pocket right now, and it starts to ring, people say, it's probably somebody I know. I think I'll take the call on my wireless device. I think I'll take it. Why? Because the protections in that law in 1991 are very high for wireless devices. It's probably somebody you know. That's what you think. But when that phone is ringing at home at night, even today, that landline phone, people look at it almost terrorized. It could be somebody I don't know. It could be somebody who's going to harass me. It could be somebody that's still calling me the same way they were in 1991 or 2001. And that's the truth. Now, should we change the laws to make it easier to call people on these wireless devices? I don't think so, because it's personal. It's on you. How much of an intrusion would that be on people to have that phone going off all day long with these robocalls? And by the way, what happens, of course, Senator McCaskill's right on the point here, these firms have moved overseas, yeah, but who is paying them? People in America are paying people in India to be harassing people so they can get around the laws. That's what's going on. We should try to figure out how to make the laws tougher so that these offshore, overseas, calls are harder to make. So if I can, Ms. Saunders, and perhaps I was influenced by the fact that I did work for the National Consumer Law Center when I was in law school, so maybe I was infected by this philosophy of the consumer should be protected first. I was there the first year the Consumer Center was established, working there as a law student researcher. So can you talk a little bit about this concept of consent and whether or not it might be possible actually to have the information come in by emails or the consumer be able to respond by emails rather than having the phone be ringing, the wireless or home phone? Are there ways of dealing with this issue that are much less intrusive on the consumer in our country? Ms. Saunders.
Yes, there are. I think the first point really needs to be made is that there's not a constitutional right to make robocalls. And before the automated systems developed, businesses communicated quite well with their customers through manual dial calls or emails or in the olden days, snail mail. And I remember getting calls from my credit card company where I actually had a person on the line who said, there's a suspicious activity. Is this really your credit card use? And there's no reason that that can't be used when the business is not sure about who actually has consented and currently owns the phone.
Well, let me ask you, Ms. Saunders, and you, Attorney General Zeller, we're talking about last year a relaxation of the laws in terms of being able to call people who have debt. And it's people with student loans. There's 40 million in America. Now it's easier to harass them by phone. can you each talk about that and what might be better ways, you know, for people to be communicated with who have debts in our country? Attorney General Zeller.
Well, again, I think at the beginning when people sign up for debt, you know, to get their opt-in as part of the, you know, transaction. And again, I'll agree that we could make that defense. So, you know, I'm not here to defend, again, the plaintiff's bar. So tightening up a better line of defense. But I would point out that it's the exceptions that I'm nervous about. And again, when we went up to the Seventh Circuit, it was clear that because we had no exceptions, the political free speech against personal privacy, two very important constitutional rights, and we won based on the fact that it was not limiting free speech. There's plenty of opportunities to speak, just not by ringing the phone. So be careful the difference between that defensive side, which again, we would support bolstering. Don't make exceptions because you've suddenly picked winners and losers, and the courts won't allow that limitations on free speech.
With your indulgence, Mr. Chairman, could I ask Ms. Saunders to respond a little bit?
The idea that calling a consumer that owes a debt multiple times will assist them in paying back the debt is somewhat flawed. I think the record is full of examples of both consumers who owe the debt and consumers who don't owe the debt being called numerous times, robocalled, which is harassing and abusive. It's also not particularly helpful and against the and not in furtherance of good public policy to bother people into paying a debt.
And again, in last year's Budget Act, there was a provision snuck into a must-pass piece of legislation that makes it much easier for debt collectors to call consumers, students, 40 million students who owe student loans, and makes it a lot easier for them to do that. And I've introduced the Hang-Up Act that would just stop that. It's absolutely irresponsible. And I ask unanimous consent, Mr. Chairman, to add 2 letters to the record, one from 25 attorneys general, led by Attorney General Zeller, who is testifying here today, and one from 16 consumer groups who have all written in support of the Hang-Up Act. So that
without objection, will be
and I appreciate that, Mr. Chairman.
Thank you.
We thank all of you for being here today.
Thank you, Senator. Being here for
Mr.
your...
Chairman,
Yes.
is it possible I could ask one more question? And that would be it.
I kind of expected that would happen. So, Senator Markey, one more question.
And I appreciate that, and I know it's an unwanted intrusion.
It's never unwanted.
But I thank you. Last year's surface transportation bill, the FAST Act, included a provision requiring the IRS to hire private debt collectors to collect certain unpaid taxes, Attorney General. That means that the IRS is going to be hiring many people to go after those who may be unable to pay their taxes. This provision, coupled with the TCPA carve-out in the budget deal, will open the floodgates to private debt collectors, robocalling and robotexting millions of Americans. The enactment of the 2 provisions coincide with the rise of tax and debt collection scams as a serious problem, costing Americans millions and millions of dollars. Last year, bogus tax scams and fake debt collectors topped the Better Business Bureau's list of top scams of 2015, with over 32% of all scam reports about phony tax and debt collectors. So, Attorney General, will these 2 changes in the budget and transportation laws on robocalls and robotext provisions make it harder for consumers to protect themselves from fraudulent tax and debt collectors?
Well, there's no question of looking at those 2 coupled together that there was this kind of interest. And again, like the chairman said, it was put into the must-pass budget. So I think this idea of making the carve-out exception really puts consumers at risk, because we've told people, you know, the IRS will not call you, and that's, don't worry if that you do to get the call. So this is not going to be a very effective tool to try to go after people, other than the harassment that if that's supposed to get things done. And I guess I would leave it that, again, this carve-out, with the exception, is going to make the constitutional question about whether the federal government has now made winners and losers in an area which is really covered with free speech. So you may have really killed the whole TCPA by that carve-out.
Yeah, so they become electronic kind of Luca Brazzis, you know, as debt collectors, but just bothering you all night long. Ms. Saunders, do you agree with the Attorney General?
Yes, I do.
Okay, thank you. I appreciate it, Mr. Chairman, very much. I think we should
Thank you, Senator
tread
Markey.
carefully into this. Thank you.